I'm Kalev Crossland and this is Law in 3 Minutes. The do's and don'ts of giving evidence. Topic 1. Credibility. The judge is studying you and assessing you when you give your evidence. So 3 things. Simple. 1. Be yourself. Act naturally. 2. Be polite. 3. Don't be a smart aleck or argumentative. There's nothing worse than that for your credibility as a witness, and you're doing no favours to the party that's called you to give evidence. Topic 2. Your written statement or brief of evidence. 4 things. Number 1, make sure that you are very familiar with your evidence. Practice by reading it aloud. Number 2, if your statement makes reference to other documents or exhibits, for example, make sure that you are also very familiar with those documents or exhibits. Number 3, and this will require some working in with the lawyer calling you as a witness, is please ensure that the language in your written statement is language that you would naturally use. And number 4, when you're questioned on your statement of evidence, try and ensure that the answers you give are consistent with what you have stated in your brief of evidence. Now, the final topic for this video is cross-examination. There's 7 things that I'm going to talk about to assist you. The first point, very simple, is when you're listening to questions and answering, give your answers to the judge, look at the judge, don't look at opposing counsel over here. Tip 2, listen to the question, think about the question in your answer, and then give it. You have all the time in the world. Tip 3, make sure you answer the question actually asked of you. The biggest mistake that witnesses make is answering a different question. Here's an example. Did you go shopping on Friday? I went shopping on Thursday. Wrong answer. The correct answer is no, but I went shopping on Thursday. Even if the question is put in a way to you that suggests a yes or no answer, and you feel uncomfortable about that, still answer yes or no, but you are able to qualify that answer. Do not, for goodness sake, start launching into the excuse or the explanation that you think is important. Answer yes or no, then give your explanation. Tip 4, don't, for goodness sake, guess. The court is simply not interested in what you think might have happened. All the court is interested in is what you yourself remember witnessing. However, there may be ways that you can qualify an answer. For example, did you go shopping on Thursday? I don't remember, but it is my practice to shop every Thursday. Tip 5, look, opposing counsel is not the enemy. Be polite, don't be argumentative. Tip 6, if opposing counsel puts something to you like, are you saying Mr. or Ms. X is lying? Don't say yes. It's better to say something along these lines. I don't know whether they're lying or not. All I can tell you, counsel, is what I remember, and this is what I remember. Or, I don't know if they're lying. Really, that's a matter for the judge. Lastly, tip 7. Answer all questions as I have outlined above in this video, unless your counsel, who's called you as a witness, stands up and objects. If that happens, remain silent until the judge has made a ruling on the objection. Now, if you want more information about giving evidence in court, or indeed in any contentious business legal matter, do feel free to contact me, Kalev Crossland, for an obligation-free, cost-free discussion on the contact details shown on this screen.